Four attempted murder suspects tied to a Catawba County mass shooting now have a little more clarity on their futures in court. Isaiah Mitchell, Tolland Huff Jr., Keandre Mack, and Zachary Bates all appeared before Catawba County District Court Judge Monday for a bond hearing. All four are now facing 10 additional counts of attempted murder.
The judge denied bond for Mitchell and Huff because they already face charges for other violent crimes. Mack and Bates received a bond of $1 million. The prosecution pushed for no bond for everyone, but the defense claims that Mack and Bates did not have the criminal history of the other two.
Now, the four are accused of shooting into a crowd of more than 100 people at that party on Walnut Acres Drive. Prosecutors in the case say they have a reason to believe that those four suspects were motivated by gang activity.
Queen City News Chief Legal Analyst Khalif Rhodes joining us this morning to talk about what it means for potential punishments if those suspects are found guilty. Khalif, good morning.
Good morning.
An unusual puzzle piece that not only investigators but attorneys are now trying to look at here. You've got possible gang-related issues. You've got multiple people that are charged. What kind of legal issues or I guess hurdles do you have when you've got multiple people working on this from different angles?
Well, there's a number of hurdles. Anytime you have multiple co-defendants, I mean, you can get be nervous as one defendant because you're concerned what the other defendant is going to say. That may have an impact on your case. But looking at the bond hearing, I guess that's the easiest way we can talk about the hurdles that are there. 15A533, 15A534. Those are the two statutes in North Carolina that dictate setting conditions for release. The judge here obviously used those statutes and the guidance that are in those statutes to come up with the conditions that he set for these individuals. So you have the two folks that got no bond, and you have the other folks that got the $1 million bond. Well, it talks about you can set a secured bond, unsecured written promise to appear, or release to a third party. Obviously, with this type of charge, you're setting some type of secured bond, but when they talk about the DA's office asking for no bond for everyone, they're talking about this thing called a rebuttable presumption. For every case outside of murder in North Carolina, a judge has to set a bond. The statute says it must set a bond. For murder cases, it says they may set a bond. So a judge has discretion to say, I'm not going to set a bond on this case because it's murder, they walk away. But every other charge in our state, they have to set some type of condition for release. And so the judge will go through that case. But when they talk about gang activity, right, that's one of those factors that will be placed in there when you talk about this rebuttable presumption that no amount of bond can be set to ensure that the community is safe. So that's why the DA was saying, hey, we believe this is gang related. We believe this was some type of retaliation. Why? Because it's going to that rebuttable presumption that even if you set a $20 million bond, the community won't be safe from these folks that are out there. So those are the type of layers that are placed in there when you have multiple people, because now they're lumped in with these other folks that are all their gang members. That still needs to be proven. If I'm the defense attorney, I'm saying, well, show me the proof that they're connected to a gang. And then I'm also saying you have two of these folks that have no criminal history at all. So why would you set no bond for folks if they have no history that shows they have a likelihood of not coming to court, that they have a likelihood of committing a crime, specifically a new violent crime? That's the standard of what the judge has to look at. That's why the judge set the bond for the other folks.
Right. I mean, even it's a high bond, even if it is no bond or not no bond there. One of the suspects here confessed to police saying that their involvement there. How does that weigh into what charges you bring, or if we're talking about a trial or sentencing down the road, does that give you any leeway for someone being honest?
Well, what I can tell you is it doesn't help. And so folks feel like when I'm talking to law enforcement, especially if you have that accountability, if you have some type of guilt for what you've done, you want to go forward and confess. And that happens a lot. But then once it's time to talk to a defense attorney to try to figure out what the strategy is to defend you in this case, oftentimes the worst thing to do is try to defend someone with their own words against them. And so when I look at the investigation tape and they're talking to them in the interrogation room, I mean, if you are telling them that you meet all the elements of the charge, I went over there with the intention of shooting, I committed the shooting, so now I've premeditated and I did the act, it's hard to beat your words, but there's still help for folks in that situation because there's different levels to this. So you ask the question, does it help? It depends. If your statements help them get other folks, then sometimes it will help in terms of what type of plea deal that the DA's office will offer you. But even in that situation, it's not guaranteed. If you don't have a cooperation agreement, if you don't have anything in writing, you're just helping and it gave you no benefit. And so oftentimes it's better to wait get legal counsel, and then have that conversation.
Khalif, real quick, you mentioned the gang involvement there, something that the police chief was talking about, the sheriff, I should say. How much does that change the way this case works out? Now you're talking about not just a local gang, but a gang with national ties.
So, I mean, the FBI is already investigating this. They were talking about it, so that's something that you'll see. That I think the gang in the national gang or probably international gang that they're not even mentioning because they're worried that it will bring some other retaliation. Those are the types of things that I think just bring other outside investigative agencies in, and it heightens the type of charge when you say, in North Carolina, when we talk about sentencing, if we get to that point, we have mitigated range, presumptive range, and aggravated range. Well, sometimes if you have gang-related activity and you're in concert with other folks, like you have multiple people here, that gang-related activity puts you in that aggravated range, which is a heightened sentence. So that's something way further down the road, but something that they want to be contemplating.
All right, Khalif, thank you very much. Appreciate that.
Queen City News Plus. Just search Queen City News on your smart TV's app store.